A concerning ruling on defamation coming out of the Supreme Court that affects how media can report on Parliament and carry that information to you. Thank you so much for joining me courtside. I'm Dionne Jackson-Miller. Time for tea. This was a case involving the Mayor of Port Maria, Richard Creary, and the media house, the Gleaner. Now, in case you don't know, the Gleaner is a member of the RJR Gleaner Group, and I work for the RJR Gleaner Group, so let's put that right out there. Mr. Creary sued the Gleaner, saying that the Gleaner had defamed him, meaning damaged his reputation. Remember the whole Petrojam saga? Well, there were a lot of reports that raised concerns about hiring practices at Petrojam and the way the organization was being run. In 2018, the Integrity Commission started an investigation into allegations of impropriety and/or irregularity, conflict of interest, corruption, nepotism, cronyism, and favoritism at Petrojam. And in 2019, the Integrity Commission published 2 reports on the issue. Now, Mr. Creary says in his lawsuit that he was wrongly named by the Integrity Commission as a member of the panel that had interviewed Floyd Grindley for the post of General Manager of Petrojam. He also said the Integrity Commission reported that he was included in a panel that recruited Yolande Ramharak, and that recruitment was found to be irregular. Now, Mr. Creary says those errors were made by the Integrity Commission and that the Gleaner published the information without contacting him or making sure that the article was accurate. In his lawsuit, he says that on July 1, 2020, the Gleaner published an article entitled Web of Corruption with a question mark, and I say that because the question mark figures into the discussion and the lawsuit. The article was based on reports 1 and 2 tabled by the Integrity Commission in the House of Representatives on June 30, 2020. There was a side story that was headlined Key Enablers, and it had the photographs of several people, including Mr. Creary. Now, the Gleaner argued that the reports from the Integrity Commission that they relied on in publishing their story were protected by the Integrity Commission Act. The reports named several individuals as part of the Integrity Commission's investigation, and the article by the Gleaner was based on the Integrity Commission's use of the phrase corruption enabling mechanisms to question the strategic placement of people at Petrojam, as was said in those reports from the Integrity Commission. The Gleaner referred to page 191 of report number 2. This is a report from the Integrity Commission that had a diagram that outlined the relationships and or affiliations between Petrojam officials, Government of Jamaica officials, and other people. So, according to the Gleaner's testimony now, the meaning of the words Web of Corruption, that was the headline with the question mark, was that the question mark was inviting a reasonable reader to pay attention to the headline and to read the rest of the story. The Gleaner said the article made it clear that the question that was posed in the headline came out or was based on statements made by the Integrity Commission in their reports. So there was a depiction of a spider on the same page as the article, and the legs of the spider pointed to different people, including one pointing to Mr. Creary. And the words Key Enablers with a question mark appeared beside the spider. Now, Mr. Creary says the article was defamatory because he says he has maintained a sterling reputation as an honest and upstanding member of society. He's a well-respected political figure, and he said his reputation had been damaged by the Gleaner. He also said the Gleaner published the article without contacting him for comment. This particular complaint from Mr. Creary that he wasn't contacted for comment is a key feature in this particular case. The Integrity Commission issued a public apology in a media release on July 13, 2020, and the Gleaner carried stories on the public apology as well as a statement from Mr. Creary. Those, though, there's a dispute about those, and I'll reference that in a little bit as well. Now, the Gleaner says the information that was used for their article was taken from those reports. Let me just say quickly in relation to defamation law. The law of defamation is what allows you to sue somebody if they say something that damages your reputation. So if somebody calls you a thief, for instance, you can sue them for defamation. The law, though, also recognizes that there are occasions when you need to be allowed to speak freely. So the law provides defenses if somebody sues you for defamation. So a big defense, which you probably know about, is truth. So if I call you a thief and you sue me, but I can prove that you are a thief, I will have a good defense against that lawsuit. Because even if I've damaged your reputation, all that's happened is that people are now seeing you for who you really are. And let me just point out, truth doesn't come into this particular case at all. I'm just giving you an example of a defamation defense. What I'm really concentrating on for the purpose of this case is what is called privilege. Now, the law recognizes that even if what you say has damaged somebody's reputation for reasons of public policy, there are occasions when you should be able to speak freely. As I said before, you have two types of privilege. You have absolute privilege. That's when no matter what you say, you have a complete defense against defamation. And for instance, think about court proceedings. You can go into the witness box and whatever you say about somebody, you will have an absolute defense. And this, of course, is because the court needs that information to be able to administer justice. So you have absolute privilege for what is said in court. You also have absolute privilege for what is said in parliament, and you may have heard sometimes somebody will say something about somebody else in parliament and they say, come outside and say it, come outside and say it. That's because if you step outside the parliament, you lose the defense of absolute privilege. And this is again a public policy issue. The law recognizes that the parliament needs to be able to freely discuss the nation's business without people worrying about being sued. The law protects what's said in court, absolute privilege. The law protects what's said in parliament, absolute privilege. But how are you, the public, supposed to know about these important issues? The media, therefore, need a defense to be able to report fairly and accurately on what's said in court and what is said in parliament, to give two examples. And that defense is called qualified privilege. Gleaner in this case relied on three defenses: fair comment, what is called common law qualified privilege, and qualified privilege under the Defamation Act. The judge rejected all of those defenses, right? And she spent most of the time discussing qualified privilege at common law. That's also called Reynolds privilege. And it's the defense that media usually rely on when you're doing original reporting or investigative journalism. And I'm not going to spend time talking about that today. There's a lot involved there. I'm also not going to spend much time talking about fair comment, because I believe the relevant and most important defense in this case was the defense of qualified privilege under the Defamation Act, which the judge rejected. So again, qualified privilege under the Defamation Act was put there to allow the media to report fairly and accurately on what has been said in Parliament and matters that have been tabled before the Parliament, therefore clearly covering things like reports from the Integrity Commission. Okay, so this is what the Defamation Act says. It says unless a publication is made with malice, publication in a news medium or other matter mentioned in the first schedule, that's later down in the Act, I'll soon tell you what that says, but this publication shall be privileged. And what else does the section say that imposes conditions on the defense? It says you can't rely on the defense if it has been proven that the defendant, that's the person being sued, has been asked by the claimant, that's the person who has sued, to publish in the news medium in which the original publication was made a reasonable letter or statement by way of explanation or contradiction, and has refused or neglected to do so, or has done so in a manner that's not adequate or not reasonable, having regard to all the circumstances. All right. So first of all, just looking at what is said here, there is no requirement here for an apology. What the requirement here is that if the claimant comes and says, "Oi, I saw you publish something about me. Can you publish this letter or statement that allows me to explain or to refute or to comment on what you have said in the story?" Then you, the news media, the journalist, whatever, you have a duty then to allow for that publication. And if you refuse, then you can't claim this particular defense. So that's one of the conditions of being able to claim this defense. The Gleaner relied on paragraph 5 in the section "Statements Privileged Without Need for Publication of Explanation or Contradiction," and the paragraph 5 protects a fair and accurate copy of or extract from any register or other document required by law to be open to public inspection. The Gleaner also relied on the section that protects a fair and accurate copy of or extract from matter published by or on the authority of a government or legislature, that's a parliament, anywhere in the world. And just to say, the Integrity Commission Act also has a protection against defamation. Again, this is a public policy issue that allows the members of the Integrity Commission to work and do their work without being afraid of being sued, and also allows for reporting on the important work of the Integrity Commission. And it says, for the purposes of the Defamation Act, any report made by the Integrity Commission under this act, that's the Integrity Commission Act, and any fair and accurate comment on an Integrity Commission report shall be deemed to be privileged. The defense of qualified privilege under the Defamation Act, therefore, requires that the reporting has to be fair and accurate. It can't be motivated by malice. Now, malice in law means that you knew something was wrong and you went ahead and published it anyway. That wasn't an issue here at all. In fact, the judge said there were no factual inaccuracies in the article published by the Gleaner based on the source material which she accepted came directly from the Integrity Commission reports. She said the misstatements of fact appeared in the reports from the Integrity Commission, and that led to the journalist reproducing the erroneous source material from the reports. She went on to say that the reports in question contained matters of high public importance and without doubt met the criteria of matters involving a state-run entity which gave rise to a public interest and right to be informed. And she said the article as a whole reproduced in summary the findings of the Director of Investigation of the Integrity Commission and met the public interest test. So as I mentioned, you're also going to have a difficulty claiming the defense if you are asked to publish a reasonable letter or statement by way of explanation or contradiction and you didn't do it. Let me say that this provision, in my view, is clearly there in recognition of the fact that when you're reporting matters straight from Parliament, there may very well be people who later on do want to respond, do want to say, hey, can I give you my side on this? But it's a clear indication that there isn't any expectation that you have any obligation to do anything beforehand other than report fairly and accurately on what has been said in Parliament or what has been, published by way of these reports. The obligation to allow the subject of the story to respond comes after publication, and then if you deny the person that right to respond, then you're going to have difficulty claiming the defense. Now, common law qualified privilege or Reynolds privilege, based on a case coming out of the UK, is what media houses generally claim when they're doing investigative journalism, original journalism, right? And that was not the situation with this story. The Gleaner itself said this was not original journalism. The judge herself said that the story was based on the information from the Integrity Commission reports. And that's why I said I don't think common law privilege is really relevant here. It's really the privilege under the Defamation Act that's critical. So the judge made a lot out of the fact that the Gleaner didn't contact Mr. Creary for comment, but we don't do that, and we have never been required to do that when it is we're reporting on something that has come straight from Parliament. Again, it's not that the person doesn't get a chance to respond. You can publish a story, the response can later come, but in cases in which, and this is all I'm talking about, when the material, the source material you're reporting from comes directly from the Parliament, we have always just reported on that material as is, and in my view, this is what the law allows, and this is what the defense of qualified privilege under the Defamation Act allows. And the implications of suggesting that we need to contact each and every person named in a parliamentary discussion, in a parliamentary report, in a report that has been tabled in Parliament. Think about the implications, for instance, for reporting on something coming from the Auditor General. We wouldn't then be able to carry those reports until we track down and get a comment from each and every person named in the report. And then what are the implications of that? It's impractical, it's unreasonable, and for those reasons, in my view, it is not at all required by the law. What the judge did here was to conflate, to join, to mix up the defense of common law qualified privilege, which does require, remember, original journalism. I go out there and I am reporting that, a particular person is stealing from the government, and I am carrying this, and this is based on an investigation I have done. In those circumstances, if I'm going to claim the defense of common law privilege, right, qualified privilege, I do need to give the person I'm reporting on the right to respond. That's going to be critical, but that is not what we're talking about. I'm very clear on this particular distinction, and I think the judge conflated both those defenses, and what she did was to bring into the qualified privilege under the Defamation Act the conditions that apply to common law qualified privilege, and therefore she is requiring under the Defamation Act, she is importing into the Defamation Act the need to give the person the right to reply, which does not at all exist there. So the judge said, I find the Integrity Commission being staffed by humans is capable of error. This demonstrates the necessity for hearing from those named in the reports. The defendant, as a Gleaner, did not consider the possibility of error on the part of the source, meaning the Integrity Commission. It relied on the nature and character of the source from which the reports emanated and the circumstances under which the reports had been produced without any attempt at contact or verification based on this belief. Again, this misunderstands and misrepresents the nature of the defense of qualified privilege under the Defamation Act. The very reason for the defense of qualified privilege under the Defamation Act is specifically to protect the media house or whoever is reporting in the event that there are mistakes made in the Parliament, or that what is said or what is published by the Parliament is defamatory or inaccurate. The judge spent 12 pages discussing common law qualified privilege and rejecting it as a defense. As I've said to you already, the most relevant and important defense here, in my view, is the defense of qualified privilege under the Defamation Act. In her discussion, the judge spent exactly 0 pages on this. 0 pages and 0 paragraphs. So the relevant provisions of the Defamation Act and Integrity Commission Act were reproduced in the judgment, and that was it. And then the judge moved right along back to talking about qualified privilege at common law. So I was looking in that discussion, for instance, on qualified privilege under the Defamation Act. I was looking and expecting the elements of the defense to be dissected and for the judge to determine whether the Gleaner had met each of those conditions. For instance, there seemed to be a dispute over the correction that the Gleaner carried. The Gleaner, though, said that Mr. Creary's assertions that the Gleaner published a negative spin were unfounded. The Gleaner says when he was shown the publication that he said carried this negative spin, and he was asked to say why he said it, his response was the way it was carried on the truncated version. The Gleaner said he couldn't identify anything in the publication that led him to that conclusion. Mr. Creary claimed that the Gleaner chose what parts of his statement to publish. However, when he was shown that the Gleaner carried a more complete version of his statement, he agreed. But then he said it was the first time he had seen it, despite the document shown to him being disclosed more than 2 years ago, meaning it had been sent to his lawyers 2 years ago. The evidence shows, according to the Gleaner, that the Gleaner published several other articles which reported on the Integrity Commission's error and Mr. Creary's initial denial of this assertion. And the Gleaner is saying those publications were a balanced report on the issues and could not reasonably be said to show any bias against Mr. Creary. So Mr. Creary is saying the Gleaner didn't adequately carry his side of the story, and the Gleaner is refuting that. So this issue is a live one that stands to be really dissected and for a proper determination and a ruling to be made on it. Because since malice doesn't come into the picture, right, this is what the Gleaner's defense is going to hinge on. But none of this was discussed at all. Now, this ruling has driven a truck through the clear intentions of the statute to protect fair and accurate reporting on matters coming out of Parliament. I've been told the Gleaner has appealed, so we'll see what happens when it reaches the Court of Appeal. But people, you need to pay attention to this. Journalists, media houses, civil society, which relies a lot on these reports, for instance, that come out of Parliament, lobby groups, all of you need to be paying attention to this. It's one of the most concerning rulings on defamation to have been handed down for years, and it could have serious implications for how the public is informed and how people are allowed to report on what comes out of Parliament. Gonna have to leave it there. Remember to like the video, share it with somebody you think might be interested, and of course subscribe to the channel if you haven't done so yet. Click that notification bell so you know anytime I drop a new video. I'm Dionne. Thanks for joining me courtside. Gone back to my tea.